This podcast and its related content are intended for listeners aged 18 and above. Some episodes may include sensitive topics such as trauma, abuse, or mental health struggles that could be emotionally triggering or distressing. Listener discretion is strongly advised. This podcast is created for educational and awareness purpose only and does not constitute legal, medical, or psychological advice. Welcome to Sunoh, the listening circle. The name Sunoh in Hindi means to listen and, more importantly, to be understood. This podcast aims to create a circle of understanding for South Asian women primarily and anyone else who may be interested in these topics, from changing family structures to work-life balance, motherhood, singlehood, and much more. We are hoping to shake off stigma one conversation at a time. This season, we're looking at separation and divorce in the South Asian context. And I'm your host, Harveen. The decision to leave a marriage is complex and can be a long journey from the point at which things are not great to taking the decision to eventually taking the first formal steps. And what often makes it all the more difficult and challenging, on top of the emotional heartbreak and societal pressures in South Asian communities, are the legal hurdles. Where do we start, what to do first, and what to even consider can be rather confusing. Because since you got married, and perhaps up till the point that you are faced with this decision, you probably believed in the forever and ever. And no one, and I tell you no one, no matter how educated or how much exposure you've had to the idea of divorce in modern culture, is ever fully prepared to navigate the myriad legal aspects that govern separation and divorce, especially when you are in the middle of an emotional roller coaster. And without a proper understanding, both men and women are at a huge risk of being taken advantage of or getting overwhelmed, or the likelihood of the process getting dragged out without any closure on either side. So we are here today to dispel some assumptions and lay out what people need to know about legal dimensions of separation and divorce in South Asia, but more specifically in India. And we're fortunate to be talking with Animesh Sharma, who is a litigating lawyer with close to 2 decades of experience in Punjab and Haryana High Court in India. His areas of practice include constitutional and civil law, commercial and company law, criminal law, and importantly for us today, matrimonial disputes. And he's handled thousands of cases and close to 100 concerning matrimonial disputes alone. Animesh graduated from India's top school, NLSIU, Bangalore, and started his career working with a senior advocate from 2008 to 2014, and then he went on to set up his own chamber in 2014, where he currently has a team of 6 lawyers working with him. In addition, he's a really good friend of mine, and we have known each other since we were 15, 16. And he has also been a big support system for me during my own divorce process a few years ago. And I think with his range of experience and legal acumen, he's the perfect person to walk us through different facets of the divorce processes in India, where he currently lives and practices. So welcome, Animesh, to our podcast. And I have to say it's quite fun for me to get to interview you. Not a dynamic we've tried before, but I'm really looking forward to having this conversation.
Thank you for having me, Harveen, and thank you for those kind words in the introduction.
Thanks, Animesh, for taking the time out for us. And I learned a lot from you when I was trying to navigate through the fogginess of my own process. But I must warn you that any embarrassing stories from our teenage lives will be edited out. So don't try that.
Yes, they're equally embarrassing for me. So
Animesh, you are here as our legal expert today. And I also want to share a little background to highlight why I feel so strongly about this topic. And we wanted to have you on the podcast. I still clearly remember that when I was contemplating divorce, we hadn't been in touch for some time because of my own struggles during that period. Thus, I actually went to quite a few lawyers before I reached out to you for advice. I was getting many conflicting opinions and I did not know who to trust. Some of the lawyers I consulted then were too conservative in their views. Some were unable to understand the emotional weight of the matter and advising me to go back to my ex's house. Some were too clinical and process-oriented, whereas others were too extreme and seemed to have their own bias about the entire legal process and how they wanted me to go through it. It took me quite a few such bizarre meetings to set up some time with you. As on one hand, we had not spoken in a while. On the other hand, I was also embarrassed about where in my life I stood at the time. At the time, and perhaps to some extent even now, I had also not disclosed to my family all aspects that transpired in my marriage. I also had not mentioned any details to any of the lawyers that I had spoken to so far as I was having these initial meetings. Until I spoke to you and opened up about things that had occurred and led me to where I found myself in a daze of choices, I felt confused and overwhelmed and did not know who to trust. As my confidence in myself was also shaken up at the moment, and I just did not know where to begin. And at the time, your invaluable advice was just what I needed to start seeing some clarity in what steps to take. So, diving finally into the question for you, and before we start getting into the actual legal aspects, is all this confusion and fear the usual experience of people stepping into the legal process in preparation for a divorce? From the clients and cases you've handled, do you see this dynamic often?
Yes, I do, Harveen. And this fear permeates no matter who my client is. This confusion and this fear is different for the husband and perhaps different for the wife. But the fear exists, the confusion exists nonetheless for both parties. For the wife, if a wife has approached me, her fears deal with what the society is going to say. Her fears deal with what is going to happen next. Her fears concern as to what the next complicated legal steps are the right next steps she should take. Should she file a criminal case? Should she file for maintenance? Should she file for divorce immediately? Should she wait a while? While if my client is the husband, the first fear that he will have that in India at least is he going to face criminal litigation? Is the divorce going to be used as a tactic to extort money from them? Is the matrimonial dispute going to lead to a custody battle? That fear exists for both the husband and the wife. And perhaps how you go to a doctor as well. You would have read a little bit online and you would have made some initial opinions, but the execution of what you've understood, what you've read, the practical aspects of it, the complications behind it, the timelines involved, the human element of it, the legal element of it. These are all questions that all parties have, which lawyers have to contend with and explain to them.
So, in your practice, like you mentioned, that both husband or wife may come to you, is that the most common one, or also sometimes couples come together? And what is the most common situation with which they approach you, if there is such a thing?
Couples will usually approach a matrimonial lawyer when they've already agreed to separate, perhaps on the basis of mutual consent or on mutually agreed terms. If the litigation is contentious, if the marriage has broken down because of different reasons, it could be violence, it could be cruelty, it could be desertion, no matter who the aggrieved party in that situation is, it is unlikely that they will approach a lawyer together because in a contested litigation, you will need different lawyers. Your stories are going to be different. Your narrative is going to be different. The scope of legal help that you will require will be different. So then, in that situation, you'll only be approached by one side, either the wife or the husband.
And can you also summarize for us where you are operating in India? What are the most common socioeconomic contexts that your clientele brings to you?
So I am working in the Punjab and Haryana High Court, and I am based out of Chandigarh. The clientele that I have is primarily the middle class, people who live in cities. There are few clients who also are from rural backgrounds. People who will approach a lawyer's office to separate on the basis of consent are going to be people who are more aware of their rights. So possibly educated people who are not so scared of the stigma that matter divorce brings with it as well. For our rural clients, the disputes that reach lawyers' offices are where things have already gone bad, where the divorce proceedings are now very combative or are not on the basis of consent, but are contested by both sides vigorously. And in such situations, there is also multiple prongs of litigation that have started. There's possibly criminal disputes that have arisen out of the matrimonial litigation that have started against the husband or his family. There could be a custody battle that is going on for the children. In India, there is an act called the Protection of Women from Domestic Violence Act, which gives the women rights of residence, protection, compensation, restraining orders. So litigation will start under those laws as well. Then, of course, there's maintenance. Maintenance can be in the form of a monthly maintenance, maintenance for the children. That also includes maintenance under the criminal laws in India.
So there seems like there are some commonalities, but there is stark difference, especially when it comes to mutual consent between rural and urban areas. So, taking a little bit of a step back to lay out the laws related to divorce in India, and you've alluded to some already, the first thing to know is what are the reasons that someone, whether a husband or wife, can file for a divorce in India? And maybe that could be a good starting point before we go step by step.
Yes, so India is a country of multiple religions. The dominant religion in India, of course, is Hinduism. And the most amount of litigation that will come to me are people who will fall within the umbrella of the Hindu marriage laws. These laws are codified in India as opposed to a lot of customary laws. For example, the Muslim law is largely uncodified as far as matrimonial disputes are concerned. I will give you an overview of the grounds of divorce that exist under the Hindu laws, and there are parallels in other laws as well. So in India, as far as a divorce on the basis of contested grounds are concerned, the grounds of divorce in India are cruelty, desertion, conversion to another religion. If somebody is of an unsound mind, if he's suffering from a communicable disease, if he's renounced the world by entering into a religious order, that is a ground of divorce. What is, however, not a ground of divorce in India under Section 13 of the Hindu Marriage Act is the irretrievable breakdown of a marriage. So if the marriage breaks down because the two parties have realized that they are incompatible or are no longer compatible, that no fault divorce reasoning is not a ground of separation. The logic behind this is that for the state to maintain the institution of marriage as a sacred institution, it is considered to be an important responsibility that the state holds, which is why the state thinks that to let people separate only because their marriage is broken down, that is not a ground that is good enough for separation. The consequence of this is that invariably, even in cases where marriages have broken down, but perhaps they have not broken down because of cruelty or violence or all the other reasons that I specified before. If parties don't consent to separation, then the only option that is left for either party is to make allegations against the other party and try to fall within the confines of these grounds so that they can separate. These are the broad grounds of separation that exist under a contested divorce petition. If both parties agree to separate on mutually agreeable terms, then the section that governs it under the Hindu marriage laws is section 13B. That petition is filed on the basis of mutual consent. This section has some prerequisites. You have to be married for at least a year. The period of separation is defined. You have to be living separately for the period of at least a year. And then the process that is followed under this section is that parties will first record their statements, and then there's a cooling off period of 6 months for recording their second statement. And if they confirm that they still want to separate after 6 months, then the court will give a decree of divorce. This 6 month period, the law has evolved now to say that this period can be condoned in certain circumstances. So these are broadly the two grounds of separation that exist.
Okay, so there are few grounds for divorce that are recognized under the law, as I gather. You said cruelty, desertion, mental health, religious conversion. That's when it's contested. And otherwise, there's the mutual consent, but there is
Adultery as well.
no adultery as well. But fact of the matter here to conclude is that there is no such thing as a no-fault divorce or irretrievable breakdown of marriage initiated maybe just by one spouse, which is a law in a lot of other countries. So this is very critical, but we will come back to this later. For now, moving to the steps that you mentioned. So you already mentioned a little bit that there is a petition to be filed, and if it's mutual consent, people have to be separated for about a year before formal proceedings can happen. Are there few such steps that you want to take us through, both in the case of mutual consent and in case of a contentious divorce?
Yes, as I said, for a petition that is filed on the basis of consent, this petition is filed by both parties together. In this petition, you have to show that you've been married for at least 1 year and that you've been living separately for at least 1 year. Then, whatever agreed terms and conditions that the parties have already entered into, which are their terms of settlement, they can be a part of your petition. This settlement can be arrived at prior to approaching the court. In these terms and conditions, you can also decide to settle a custody dispute. Who has primary custody of the children or the child? What are the visitation rights concerned? Alimony can be decided, or if maintenance has to be decided, education of children is concerned. All of that can be decided in this petition. As I said, that period of 6 months period, which is that cooling off period, that can be condoned by law. If a petition is filed on contested grounds under Section 13 of the Hindu Marriage Act, the procedure then is that the party concerned will approach a lawyer and will narrate his or her version of what has happened. This will include all the incidents of marriage that they've faced, all the cruelty that they've faced, the humiliation that they have perhaps faced, the circumstances that led that person to seek separation. The lawyer will then draft this petition. They will include all these facts. If it's adultery, for example, that will be included as a fact situation, which will be the ground for divorce. If it's cruelty, you'll include all forms of cruelty. This can be physical cruelty, this can be mental cruelty, this can be sexual cruelty. In cases, for example, when the husband will file a petition, he may say that the wife has not taken enough care of his parents, and therefore that is cruelty, or has tried to separate the son from his mother and father, and that is claimed to be cruelty. I'm not justifying here as to what is right. I'm just trying to tell you what grounds of cruelty can exist in certain cases. So you will then lay down these grounds of cruelty in your petition, and the other side will then be called upon to reply, to file their defense or their written statement to counter the allegations leveled against them by the petitioner. That process will then be followed. They will file their reply. The court will then put the case at the stage of evidence. The courts also know that a lot of these incidents happen behind closed doors. You will never have clear cut evidence. Things that happen behind closed doors will always require circumstantial evidence to prove as well. So this evidence can be led in the form of statements of the aggrieved person. It can be in the form of the statements of their family members, their friends, emails, text messages that have been sent. If there has been violence, is there any medical record? If there has been mental violence, is there any record of going to a doctor? All of this is evidence that is used. Eventually, when both sides will need evidence, the court will then arrive at a decision to conclude as to whether the grounds specified in the petition are good enough for grounds of divorce. At multiple stages during the process of a contested divorce petition, courts will always try to get the matter mediated between the parties. So there will be efforts made at settlement. There will be efforts made to send the parties to court-appointed mediators who will ask the parties to either try to live together again, if it's possible, if their differences are small, or they will then say, if it's not possible for both parties to live together, then the best way to move forward is to separate on the basis of consent. This process will also be undertaken by the courts because, as I said, the courts also feel that marriage as an institution should be sustained wherever possible. I wouldn't, again, cast an opinion on this attitude, but the courts do start with an assumption that if it's possible to save a marriage, they should try to do so, especially when children are concerned, because as far as children are concerned, the law that has now evolved is that what is in the best interest of the child is a paramount consideration for the court. So co-parenting is something that the courts will also now try to encourage.
Wow, this seems like there are a lot of variations and a lot of complicated choices to be made in the whole process. But generally speaking, what would be an average time for the mutual consent where there is no contentious issue? What is the average time that takes for the whole proceedings to conclude?
For a petition filed on the basis of mutual consent, you will go to court on the first date, and then both parties, both the husband and the wife, will record their statements to say that they want to separate on the basis of consent. And if after 6 months both parties stick to their statements and affirm their initial statement, the courts will then grant the decree of divorce. So the rough time period is 6 months. As I said, this 6 month period can now be condoned. So in that situation, you could possibly get a decree of divorce even within a month or two. However, I would say in most cases, the courts will impose the 6 month period. So then the timeline would become 6 months. It's only when you move a specific application for the condonation of the period that the court will make a judicial decision to condone it. As far as the contested divorce petition is concerned, that is a long process in India. Sometimes the process is the punishment in itself. So allegations will fly, counter allegations will fly. At each stage, there might be offshoots that arise from litigation. So there could be a mediation dispute, there could be a maintenance dispute, there could be a custody dispute, there could also be criminal disputes that arise out of a matrimonial dispute. This process in India can take from anywhere between half a decade to even a decade. So the process will sometimes be so onerous and so time consuming that after a while, both parties will want to give up. Often, the legal strategy of the perpetrator is perhaps to arrive at a stage where the other party will just give up. So they will try to flag the litigation as much as possible, to delay it as much as possible.
So, this is still a bit of a surprise to see that it is such a burdensome process on both parties, but then everyone keeps going in those circles to prolong the whole process. Can be very excruciating for everybody. And then going back to the topic that you mentioned on in a contested divorce, different proofs and evidence need to be put together. What and on whom is the burden of proof in the case of health or mental health issues? What kind of proofs would be necessary, like you mentioned about texts and emails? If you could take us through that a bit.
So the burden of proof is always on the person who's making the allegation. Let us say, as an example, if it is the wife who says that she has been subjected to physical cruelty or mental cruelty or any forms of cruelty, then the initial burden to prove that fact will be on the wife. How she will go about it is that her own testimony will have strong probative value. By her own testimony, I mean when the wife will come to court and allege that this is what she's gone through, she will be put to cross examination by the husband's legal team. And how she goes through that cross examination, that is an important factor for the court. If her testimony is unshakable even through the cross examination, then the courts will acknowledge that fact. The other forms of evidentiary values are statements of family and friends. If you've spoken to friends during that time, those people can come and give evidence. Family members, if there are neighbors who've seen incidents, if there are medical records, for example, in cases of violence or in cases of sexual violence, those medical records become proofs which can be led in evidence by the wife. Once the initial burden of proof has been proven by the person who's made the allegations, the onus will then shift on the other person to negate those allegations. So they'll then raise their own defenses to say that these allegations are not true. In fact, what has been said is only a one-sided story. If the wife has made the allegations of cruelty, the husband will make counter allegations of cruelty. He will say that there was no violence. He will say this medical record is forged, or he will say the people who are leading evidence in support of the wife are interested witnesses. It then becomes the court to weigh the evidences that have been led by both sides, to consider what it feels is the truth, and then arrive at the decision.
This seems like a very hard ask, for women, especially if women have been subjected to abuse or violence. And this is just my opinion that often women who've faced a tough situation at home, they would probably have had a repeated cycle of it. And over time, have less confidence, less support. There are rarely ever any eyewitnesses. So, this burden of proof on them initially is a really tall order because they would probably have very little evidence to prove it. Or maybe is it true to say that the claim of violence needs to be bad enough that a court will accept it? Do you see this as being a true assumption?
Well, yes and no. Yes, in the sense that it is hard. This initial burden of proof is hard. Often, at least in India, women will go through a cycle of violence for many years before they gather the courage to come to court and speak about them. And so, if several years have passed between incidents, if incidents took place decades ago, then one of the defenses the husband will take is that, look, she's alleging something happened 20 years ago, 10 years ago. How can you believe that it's true now? Why did she not speak up beforehand? So, these problems are real problems. Having said that, the courts are aware or have become aware over the course of the last few decades that this is the truth in marriages. Often these harsh realities do not surface easily. Women in India, women elsewhere also, have been taught not to speak openly about these things. The societal pressure and the shame that is associated with going through these incidents is certainly more on the woman. So this fact, I think courts have gotten slightly better in acknowledging. And so even if allegations are old allegations, or if some time has passed, or if there is not direct proof of any violence, but the testimony of the wife holds, or if there is some sorts of messages or emails or apology messages, which often is the case. I've seen matrimonial litigations where after an incident has happened, the husband has sent apology messages. Those apology messages are, of course, not very direct. I mean, he's not going to say, I'm sorry for beating you up, but there'll be repeated apologies. Now that becomes a proof. Courts which deal with these cases day in and day out perhaps get a sense of where the truth lies. They have now experience to arrive at these decisions. Many a time, as I said, perhaps when this process is going on for a long time and courts have attempted for the parties to mediate between these disputes, perhaps parties will arrive at a settlement. In many cases, in matrimonial disputes, cases often don't reach culmination because the process is so long, and somewhere between the process, both parties will decide to settle the matter. There can be a financial settlement, there could be terms of separation. Sometimes, if the wife is so fed up of the husband, or if she's gone through such cruelty that she wants to leave the marriage immediately, she might not even ask for alimony and say, forget the alimony, I just want to be out of this terrible situation. That's what I want for my mental health. Then that's what happens. So, yes, the initial burden of proof is hard. Courts have gotten better at discerning where the truth lies. At least that's my hope that they have. Perhaps in the urban setting that I am, that's the truth. In various local and rural settings where trial courts are not as forward looking, it's even harder.
And it's good to know still that courts are also changing their outlook and understanding how difficult it can be. Because I think you earlier did mention that the courts have a bias in preserving marriages.
So the need to preserve the marriage in India comes from various factors. It is considered as a religious requirement. Often it's considered to be a sacred institution. That is one reason why the government, which is the custodian of the society, will say marriage should not be broken up easily. It's a traditional requirement. Unfortunately, India continues to be a predominantly patriarchal society. In a patriarchal society where the wife is not on equal terms with the husband, in such a society, again, to preserve the institution of marriage in a male dominated world becomes a power structure that favors the man, and therefore the society wants to preserve that structure. And courts often consider that the social fabric of the country must be protected and maintained. They will try to ask parties to live together where they can, especially where children are concerned. I would say that even if that is successful in perhaps 10% of the cases where mediation processes can lead for parties to live together, that process isn't bad. But the attitude that marriage is sacred and must not be broken, even if there is violence, even if there is cruelty, even if there's adultery, that attitude has gotten better but needs to change not only at judicial levels but certainly at societal levels as well.
Yeah, I guess a lot of this, as you said, rightly rests in patriarchy. And this reminds me of maybe one particular legal aspect here. I think it was something you educated me about when I was going through my divorce, is that you told me that during the separation period, where husband and wife are living apart, if the wife has left the home, that legally a spouse can request restitution of conjugal rights. Can you share more about this? What does it mean and why does it even exist in Indian law?
Yes, restitution of conjugal rights, it's a British concept. It was brought in by common law in the Indian subcontinent. Of course, the British have now abolished it in the 1960s, I believe, but it is codified in Section 9 of the Hindu Marriage Act as well as in the Special Marriages Act. The Special Marriage Act is the secular law in which people of different faiths can also get married. Restitution of conjugal right exists under both the Hindu laws as well as the Special Marriage Act. This is a gender neutral law. So either the husband or the wife both have the right to seek restitution of conjugal rights. And the section states that when either the husband or the wife has without reasonable excuse withdrawn from the society of the other, the aggrieved party may apply to the court and seek restitution of conjugal rights. So this phrase without reasonable excuse or without reasonable cause is important here. It does mean that if, for example, the wife can show that the reason that she's left the husband is because of violence or cruelty or desertion or adultery, then that would be a valid reason to leave the society of the husband. In that case, the court will not say that you still must join your husband so that his conjugal rights can be restored. Again, this law in the common law was brought in by the British because at that point of time, the wife was considered to be chattel, to be considered that to be the property of the husband. Often, in fact, I will say most often, it is the husband who will file a case for restitution of his conjugal rights against the wife and not the other way around. In fact, when the wife has left the house of the husband but has not yet filed any litigation, if the husband then approaches a lawyer and fears that litigation will follow from the wife's side, perhaps the lawyer will advise him to file such a case of restitution of conjugal rights, so that in a situation where the wife then subsequently files the case, you have the defense of claiming that, listen, because the husband filed the case first for restitution of conjugal rights, now all of this is just a backlash. This is because the husband approached the court first, now the wife has approached the court. That often happens. The idea of litigation then becomes not to win the litigation, but to embroil the other side in more litigation. Also, in a situation where the court passes a decree of restitution of conjugal rights in favor of either spouse, it is not that the other person can be physically forced to go to the husband or the wife's house back to them. If despite such a decree you have not joined, the husband will then say, listen, I have a decree, but my wife hasn't joined my house again. My conjugal rights have been defeated. I want divorce. That becomes a ground of divorce. So this is used as a strategy in those cases. It's an archaic law. In my view, it shouldn't be on the statute books at all. Presumes that the wife in most cases is somehow secondary to the husband. What is conjugal right is not really defined under law. Does conjugal right means the right to live together or cohabit together? Does it also include sexual rights? In India, there is no law which criminalizes matrimonial rape. So if the wife does go back to the husband's house because a restitution of conjugal rights decree has been passed and then is forced to undergo conjugal rights forcefully because there is no criminalization of marital rape in India, you can't even allege that. Yeah, these are problematic laws which are archaic and which should not be on statute books, but exist nonetheless.
These laws are indeed very archaic and antiquated because honestly, I remember when you first told me about this, I was extremely surprised. And I'm just imagining that for women who are already leaving a bad marriage, a bad situation, perhaps abuse, the idea of thinking of cohabitation and being in the same space, let alone any sexual intercourse with the partner in question, this is a whole different episode perhaps that we need to talk about, that the rights of women's bodily autonomy and the linkage with the marital rape law. Coming back to also the other processes that you've been describing, it is overall a narrow set of reasons that we have in our legal system, where in order to get a divorce, if it's not on a mutual consent basis, you have very few options. And there are a lot of hurdles, like the pretty shocking ones that we've just spoken about. And it makes it extremely difficult for one spouse, if they are not happy, to get out of this marriage. And all the more if it's an abusive marriage, which we haven't gone in depth of. If we look at it from the point of view of a woman and legal rights and risks, should a woman wanting a divorce leave the house or not? Would she be exposing herself to any legal consequences if she is the one to move out before any such formal litigation is filed?
In my opinion, if the marriage is an abusive marriage and if there is threat of violence, the woman should certainly leave the house as soon as possible. If there are children involved, and the children are minor children, I would advise the woman to take the children with her so that the primary custody remains with the woman, with the wife, in cases of abusive, violent marriages. However, there are situations where there is nowhere to go. Sometimes the family of the wife is just not supportive. Sometimes, because of a traditional patriarchal society that we are from, they will discourage the wife to leave the matrimonial house even though there is abuse. In a situation like that, where do you go? There are not too many government options or support groups, or there are a few NGOs, but those steps are hard to take. You are fearing societal backlash. Of course, people will point fingers, will make insinuations. However, in abusive marriages, wherever it is possible, if you have to leave and go to a relative's house, do that. If you have to leave and go to a friend's house, do that. Once you leave, the law does provide for avenues where you can seek for alternate accommodation, maintenance, so that you can take something on rent, maintenance for the children, for the education of the children. So do not continue to be in an abusive marriage. Abusive marriages can turn very bad. Violence can have permanent consequences, not just physical consequences, even permanent emotional consequences. So as hard as it is to take that first step, my advice would be to take it as soon as possible where there is abuse.
You're caught in the middle to save yourself, and you don't even have a supporting family to get through this. And I'm glad at least there are some NGOs and legal process to create that option for women. I'm just wondering that in a case where it's not an abusive marriage, but if the woman is choosing to leave the legal residence of her spouse or her in-laws, legally, will that disadvantage her later in terms of her own legal case or in case children are involved and it's not an abusive marriage?
So not necessarily as far as property rights are concerned in the country. In India, there is no automatic 50-50 split of property once a marriage has happened. Properties that have been created post marriage in a relationship do not automatically become owned equally by the husband and the wife. So if you leave a marriage because the marriage is broken down for different reasons, and if you have a place to go, that in itself will not prevent you from exercising your legal rights. You can claim your maintenance rights, your custody rights, your alimony rights, your property rights if there are properties in your name or joint lockers, etc. Of course, if you've left and have refused to come back without giving any reasons for leaving, and some considerable time has passed, then, as I said, desertion is a ground of divorce. So, one thing that the husband can claim after some time has passed is that I want separation because the wife has deserted me, and that period is 2 years under the law.
Okay, that's an important legal fact. I was not aware of this. Going back to the topic of child custody as well, because you mentioned a little bit on when it's an abusive marriage, the woman should definitely take her children with her and leave the place and be in a safe space. But in case of mutual consent or at the time where it's not an abusive marriage, are there standard practices when it comes to custody agreements, or is it on a case by case basis? And in case of abusive marriages, are there sole custody or limited visitation rights possible for the spouse? Like, if you can explain both the scenarios for child custody.
Yes, for the courts, as far as child custody is concerned, the paramount consideration, and that is how the law has evolved, is what is in the best interest of the child. That is the consideration that matters to the courts the most. Now, in cases where the parties have separated mutually, the terms of separation parties will agree to. So often, your written terms of settlement will have which is the parent who has the primary custody already decided upon. If it's the wife, your settlement will say that the child will stay with the wife and the husband will have, let us say, visitation rights over the weekend or in vacation or on a monthly basis, bi-monthly basis, whatever the term. Sometimes when parties are separating and the children are young, often I've seen in cases that husbands have totally given up their rights to the children as well because they don't want to be in the marriage as well. In a contested petition, if the child has been taken by one parent, the remedy that the other parent has is to file for custody under the Guardians and Wards Act in India, in which case you will file a petition saying that you are or you should be the rightful guardian of the minor child. And let us assume where the mother has taken a minor child or minor children with her, the father, the husband may file a petition saying that I am better suited because I have better means of bringing up the child, or the children have been taken away from, let us say, their school where they were studying, or the allegations leveled against me are false and the wife is going to poison my children against me. So I must have visitation rights. In many cases, when there are disputes which are not arising out of violence, let's say, but because of differences, often children, unfortunately, are used as bait. So if one parent has taken the child away without the consent of the other parent, that is a strong bargaining factor that parent has. If you can restrict access to a child for a parent, that is very hard. But in many cases where the husband has approached me in litigation, one of the biggest factors for them is that their child has been taken away from them without their consent. And because if the child is young, she's a 5, 6, 7, 8-year-old child, and she's hearing only one side of the story, then the husband or the father really feels that my child is going to be poisoned against me. I will have no relationship left. So please grant me some custody rights as well. So in those situations, courts are considerate. They will try to not restrict complete access to either spouse. In cases of violence, that is different. In cases of violence, if you're able to show that it is for the paramount welfare of the child not to be in the presence of a parent who can physically hurt her or him. And in most cases, it's the father that will be prone to violence. And you can show that, then of course, courts can grant permanent custody to only one parent and can restrict visitation rights in abusive marriages or where there's fear of violence or even sexual violence.
So it seems that spouses are also kind of using their children in the middle of these negotiations. So just recapping a little bit, what you're describing is that there is no possibility for a no fault or irretrievable breakdown of the marriage, for divorce where only one person wants to leave. So the things have to be in really bad state before someone can unilaterally pursue divorce under the Indian law. Abuse, mental illness, physical illness, desertion, adultery was some of the factors. And so, what this means in practice is that the bar is so high to divorce that people desperate enough to get out of marriage are faced with having the burden of proof, having financial autonomy. In worst case scenario, some may even be lying or trying to create conditions that are bad enough to be able to ask for divorce. And you've mentioned the retaliatory nature that these claims can have, the counterclaims that people can file against each other, and the process can go on and on. You've also brought up that how children are drawn into this or they just walk away and give up. And obviously, false allegations in the middle of all this can have detrimental impact on reputation and in extreme cases even worse. For example, I think in one of the recent news cases we saw that a long drawn divorce case where a man committed suicide due to the allegations being brought against him in a divorce proceeding. What other unintended consequences have you seen in practice or that you're aware of? And what are the situations you most commonly see on misuse of the law, whether by men or women? If you can summarize that for us.
Misuse of the law is a problem. But misuse of the law is a problem for any law. Unfortunately, misuse of matrimonial law has become a buzzword, especially recently. The incident that you described was picked upon by a lot of groups, especially men, saying that, look, this is what happens if you give women too much autonomy and in the name of feminism, if you give so many rights, then this is what happens. And so that became a sort of a clarion cry, and there was a lot of societal backlash. That was an extreme step that the husband took in that particular situation. I'll not go into the facts of that particular case, but the consequences that follow matrimonial dispute, often it is the children who bear the most consequences, because the psychological consequences that a child is facing are hard to put in tangible terms. I have a case that I was dealing recently where a 14-year-old girl was living with the mother and the father had bi-monthly visitation rights, which he was claiming the mother wasn't complying with. The mother had made a statement in court that she'll facilitate phone calls with the father, and she'd given the 14-year-old girl a phone to speak to her father on her own, but she was not speaking to her father on a regular basis. So the husband had filed a contempt case in the court saying that wife is not letting me meet my daughter on a bi-monthly basis, and she's not facilitating phone calls. The High Court tried to mediate in the matter. And so they called the girl child to the court. Now, she's a smart, intelligent 14-year-old girl who doesn't know who to please in this situation. She doesn't want to displease her father. She's very clear that she wants to meet her father, but she wants to live with her mother. But when she meets her father, she doesn't want to displease her father. The trauma that the child faces is very real. She broke down in court. So therefore, to find justice here somewhere in the middle so that the rights of everybody concerned can be protected, it's a hard task. That is one consequence that comes out of matrimonial litigation. Another sort of misuse of the law that happens a lot in India, which the Supreme Court and other courts have also spoken about, is that often when the wife will file divorce on the basis of cruelty, as strategy, as a pressure tactic, she will involve the entire family of the husband. In many cases, those allegations are true. In many cases, because in India, people live in joint families, the wife has faced cruelty at the hands of, let's say, her in-laws. But in many cases, it's also not true. But if you cast the net so far wide, so as to also include married sisters who are living separately, relatives who are not even in the same city, and you make allegations of serious nature against all extended family members, because it's easy to make allegations of cruelty, it's easy to make false allegations of dowry, for example. And when you make these allegations and entire families are then brought about under criminal proceedings, that is a serious consequence that leads to the abuse of the law. In India, these laws I would feel are still required because given our history, given how much cruelty, how much subjugation women have faced in the country, how much abuse largely they have faced, the fact that the law can be abused and is abused is a reality. But as I said, that is a reality for many laws. Abuse of law can happen in the context of even theft. You can make false allegations of theft against somebody. That doesn't mean you delete the offense of theft. So these laws which exist for protecting women while they are abused, and often they are actually abused because the legal advice that is given to the wife is that you rope in everybody. And if you do that, the eventual settlement that you'll get will be better because the husband will get scared and then he'll settle on your terms. That is something the lawyers will also advise. That happens. Unfortunately, that is also the truth. So that is a serious misuse of the law. Having said that, I still feel these laws should not be removed merely because they're misused. These laws should exist. Courts can evolve and can look at these laws and arrive at serious repercussions where allegations that have been made are found to be false so that people will not abuse it. But you cannot delete these laws merely because they're abused.
I'm really glad you've given us this summary, Animesh, because those social media posts were very triggering for many women rights movement, and rightly so, because everybody feared that will there be an undermining of certain laws that have long existed to also protect the real cases of abuse and violence that women have faced. And I'm glad you give us that summary because this means that perhaps the cases of false allegations might be a minimal number. I don't know if such statistics exist, but that's what I'm hearing from you. Is that correct?
Yeah, there are not many clear statistics in the country. It's also hard to find out which cases are real and which cases are false. But I would say cases of misuse are perhaps much lower than the real cases of abuse.
But going back to the false allegations, in such cases, how is the truthfulness of claims judged? How is a judge or the court proceedings even factoring this in?
Well, that is the burden then lies on the judicial process. If there are allegations of false and the husband can lead evidence to prove that these allegations are false, if extended family members can show, for example, that they were not even in the city or the country when allegations against them were moved, or that they've never even come to the matrimonial house of the party is concerned, and they've just been roped in because they're relatives and as a pressure tactic, then courts will side with them. In fact, one of the grounds of divorce that has been judicially evolved is that if it is found that the allegations that have been leveled against the husband or his family members were false and a judgment to that effect has come, the husband and his family have gone through a criminal trial and have been acquitted, that alone is a ground of divorce. That is considered to be cruelty on the part of the wife to subjugate the husband through such a process. Then this is the consequence.
Switching gears a little bit, if you can also walk us through a bit on the costs people need to be prepared for when contemplating divorce, especially because most often in South Asia, majority of the women in urban areas, rural areas may not be equally financially independent. It's changing in urban India, but they may still have lesser financial autonomy. So, for those who cannot afford a lawyer, or especially women at risk who may not have access to their own money or separate bank accounts, what provisions are there? And are there legal aid options or not for profits that you mentioned briefly before?
There are legal aid options. They are not the best options, but the legal aid options exist. You can go to court and say that you do not have legal representation, and then the court will provide for legal representation to an aggrieved party. If you can show you're indigent or if you do not have enough funds, there are laws which say that legal representation can be provided. There are also many NGOs in the countries that do come to the aid of women who have faced abuse, come to their aid by providing either financial aid or legal aid or support groups, etc. The costs of litigation otherwise are undefined. It depends on multiple factors. It depends on in what direction the litigation has gone. how many offshoots that one litigation can lead to. As I said, a matrimonial dispute of divorce can lead to maintenance matters, can lead to custody matters, can lead to protection of women from domestic violence matters, can lead to criminal matters. So if there are multiple matters, there'll be litigation costs in all matters. Often there are women who cannot meet these litigation costs, and if they file for maintenance or interim maintenance, and that maintenance is granted to them. Sometimes they'll meet their legal costs through that maintenance. But what happens in poor families, let's say where maybe the husband is only earning 20,000 a month, that is in Indian rupees, and so that will come to about 200 to 250 euros a month. And that is the reality of many people in the country. People are earning in that range. And if you have to provide for maintenance, how much maintenance can you provide? So if out of 200 euros, even if you do provide maintenance to the extent of, let us say, 100 euros, is that enough for anybody to sustain themselves? Litigation costs also spiral because litigation takes so much time. In fact, this is also one of the reasons why sometimes where parties do not want to settle matters because they face, let us say, abuse or violence, sometimes they are forced to settle. So if the wife is getting a financial settlement that secures her future and her child's future, perhaps even if she has faced violence, she'll agree to that settlement because the litigation is ending. The process, which is such a long, arduous, time consuming process, which is in itself the punishment, is ending. You're securing your rights. And for the husband, if he is entirely certain that he is the wrong party, but for him, he'll settle by paying an amount to the wife because for him, it's like buying his peace. He'll be told that this is the best way forward to move on. And you're the one who's the victim here because the law is on the side of the woman. It's better to just settle the matter right now. So costs are undefined. They can spiral. Lawyers' fees are also dependent on the capacity of the client to pay. If it's a high profile matrimonial litigation, lawyers will also charge accordingly. If the people who have approached you are already not very well off, then you'll adjust your fees accordingly.
So it seems that both the financial and emotional cost is really high and unpredictable depending on where the case is. And as you said, the process in itself is so complicated and can get complicated even if you don't want to, that may be punishment enough. Coming to maybe the post divorce situations, are there any post divorce legal aspects that our audience should be aware of that we haven't covered? Like, are there any other specific details on alimony or custody changes after the divorce petition is finalized?
Yeah, so if the divorce is on the basis of consent, those terms will possibly be decided in your settlement agreement, custody, visitation rights. In India, maintenance can change depending on the change in circumstances. So let us say you have gotten divorce and gotten some maintenance. If your circumstances have changed, if the husband's circumstances have changed, if their earnings have increased, the wife can claim further maintenance as well. The other factors to consider are custody disputes that may arise. Divorce does not necessarily mean that custody disputes end. Circumstances change for the child. Courts can once again interfere and decide what is in the best interest of the child. Change custody, change visitation rights. Once the child is beyond 18, custody does not become a moot point because the child is considered an adult in law. He or she has the right to live wherever she wants with whichever parent he or she wants. These are some factors which are in addition to what happens during the divorce process and post the divorce process. These are the legal aspects. Of course, the social aspects are perhaps more severe though, because the stigma that is attached to divorce, especially for women, will only come once she is the divorced woman. So there is judgment in Indian society. There is social pressure. It's harder for divorced women to remarry in India, especially if you have children. It's even harder still. So it's harder to move on. It's easier for men to remarry, even if they are divorced. But for women, you're considered to be, unfortunately, second-hand property. So that just becomes harder for women to get married in India. So that's a big problem. These social issues that arise post-divorce are very real, very difficult, and this is where you need support groups. This is where you need people to step up. This is where you need society to step up. This is where you have to destigmatize divorce. This is where you have to say that it is not the fault of the victim to have gone through the process of divorce. It is the fault of the perpetrator.
And I think our podcast is a part of that kind of support that we want to create. And we could obviously spend hours talking about stigma, and you've brought it up quite a few times. What I want to ask you now is that Do you see a relationship also between the stigma and the law? Which one is driving which?
The stigma doesn't drive the law as much. However, as I said, the courts and the governments do have a vested interest in trying to preserve marriages. And for the wife, even if you have to endure things so that you can continue to be married, that thought process still exists. In that sense, there is some relationship between the stigma of separating and the law trying to make sure that marriages can sustain when the ideology of the court or the judge is coming from that point of view.
It's at least heartening to see that in some cases we do see changes or some evolution to stigma and how divorce is looked at in urban areas. But as you said, it's maybe not changed enough or percolated enough in the society. And I'm not a lawyer, but generally hearing you, I can see here three major flaws. One, that you as an individual can't make a choice if you are unhappy in a marriage and unilaterally want to end this. Second, people could make false allegations in order to create a pressure tactic on an unwilling spouse to agree to a mutual divorce, which can ruin their reputation or be costly affair from finance and time point of view. And the third, a very critical part of this would be a flaw where the women's autonomy to their own body is subjected to very old fashioned laws. At least that's my take. So, what are your thoughts on this, and what changes do you think are needed in the legal system itself to create this societal larger change on how divorce is perceived?
Yeah, I would largely broadly agree with the three problems that you pointed out. I definitely think that no fault divorce or divorce on the ground of a marriage breaking down should be included as grounds of separation under Indian laws. In fact, the Supreme Court does keep this power to itself under Article 32 of the Constitution of India. In certain cases, if the marriage is broken down, the Supreme Court alone has the power to grant divorce only on the ground of breakdown of marriages. And there have been recommendations over the course of the last few years to include the breakdown of marriage as a ground of divorce. In my view, this should be done. This does solve many problems. It can prevent false cases from being filed, which was the second problem you pointed out, because you don't have to make false allegations against the spouse concerned if you are able to just claim that you do not want to be in the marriage anymore, even though the other partner wants to be in the marriage, that alone can be ground of separation if the court feels that the marriage has indeed broken down. As far as the second problem of people facing false litigation as means of coercion into settlements, I think the solution there is that in cases where it is found that false allegations were leveled, the repercussions should be severe. There should be consequences that should follow so that there is a deterrent effect. But as I said before, also, any law that exists on a statute can be abused. So the mere fact that there's potential of abuse of a law cannot be a ground to set aside that law. So I feel laws that exist for the protection of women in India should only be strengthened. They should not be weakened. But consequences for abuse of this law should be severe. The third issue that you pointed out, as far as bodily autonomy of women are concerned and restitution of conjugal rights is concerned, this question is once again open before the Supreme Court. And lots of women's rights groups are arguing that this law should not be on the statute book anymore. It does not serve any real purpose. It is in fact only abused more than used validly. It is an archaic law that should not exist.
So, what are the biggest mistakes people make during the divorce process? Do you have some key do's and don'ts for people who are contemplating divorce to have the best legal outcome and be able to carry on with their lives after?
No easy answers there. There are many answers actually. I would say one mistake is to continue to be an abusive marriage. If the marriage is abusive, you should get out of it as soon as possible because the abuse is only going to get worse over the years. In my experience, in cases where people have stayed in abusive marriages for decades, and then eventually, when if a wife has, for example, left, the mistake that she's made is that she's given the husband an argument to say that, listen, all these allegations are decades old. If they were true, they would have been brought up earlier. So don't stay in an abusive marriage. Don't be afraid of the stigma of divorce. I don't think the stigma should exist. I don't think it is valid. I think things are getting better. And I think it makes sense for somebody who wants to leave a marriage to take legal advice to be aware of their different rights, to be aware of their different maintenance rights, custody rights. So approaching a lawyer does make sense. Approach a lawyer as soon as possible. Don't make false allegations. I hope that holds true for either party. False allegations, even though they are made perhaps with the intention of arriving at a settlement, often backfire also. If you file false criminal cases against the husband, for example, in many situations, the husband will think, this is the worst that can happen to me and it has already happened. So now I might as well fight it out. So these are some mistakes which and should be avoided.
It's interesting you said that the stigma is changing. And I just wanted to say that I personally, as of now, haven't felt that stigma, probably because I don't live in India and my community in Germany is hardly Indian community. But I have heard that from some expats recently that have even hidden that they are divorced and they've just stopped attending larger family gatherings and being present because they're going to be asked questions. I think in my case, I felt there was a strange silencing of this aspect of my life, and people would tiptoe around me. And even some well intentioned family and friends who spoke to me, sometimes they would speak to me in a very pitiful manner, as if my life was now over. And I also know that for many others who have felt a certain stigma, whose parents did not support them, they had little to no help from family and friends who abandoned them to even be a part of these conversations because their spouses felt concerned that, is this going to influence my wife? And in my opinion, there's also very little public dialogue, discussions, and resources for Asian, South Asian women to comfortably talk about the challenges and start normalizing this as a reality of modern day life.
That's true. I agree with you. I think this has to be normalized as much as possible, as soon as possible. Sometimes marriages break down because people have changed. Society should acknowledge that. Perhaps if we do, we can remove the stigma, reduce the false cases, and move to a kinder society.
Thanks for sharing that with us, Animesh. It was great pleasure to have you and take your time on such an important topic. You've shared immense knowledge and useful tips for women, men to consider different legal aspects. Many learnings from this can perhaps simplify some things for them. Thank you so much for your time and such useful advice.
Thank you. It was a pleasure being on the podcast, and I hope if it does help even a few people, I think that would be a good start. Thank you again.
This conversation really reinforced to me how our legal system wants to preserve the state of marriage, but is doing so in a way that is so burdensome and for some making it impossible to ever escape, especially since one sided divorce options do not exist. Even a mutually desired divorce requires jumping through so many hoops, much less a complicated or a contested situation. What's clear to me is that we really need some kind of legal reform so that women and men can divorce amicably if they so want to, and can also get out of abusive situations more easily if they need to. I was actually most glad to hear from Animesh that even if sometimes laws of any kind may be misused, that should not be used as a means to dilute the laws that protect women in the most vulnerable situations, but perhaps other stricter measures in case of misuse of laws can be adopted. I think when Animesh used the phrase that in India women are like chattel or women are like used goods, or that's how the society perceives them as, I think something inside me just froze. Because these phrases are used in South Asia for divorced women quite rampantly. Even if in some niche groups divorce may have now become a bit more common, the notion of women as someone else's property in the first place is just plain uncomfortable. And an idea to accept in today's time and age just doesn't go very well. And we hope that with conversations like our podcast, we can shake off even such language pertaining to divorced persons, especially women. Thank you for joining us. If you valued this conversation, please share the podcast, rate it, and subscribe to Sunoh wherever you get your podcast from so that you get notifications with each new episode. It helps more people to find us and join this community. You can also find all the details about the guests in the show notes as well as on our social media pages. Please note that this podcast is for informational purposes only and does not replace legal, therapeutic, or other professional guidance that you or someone close to you may need, catering to their specific situation. If you are in a dangerous situation, please contact the nearest hotline or authorities where you can find the help you need. Since our podcast caters to global audience, we are unable to share a lot of country-wide resources. But I'm sure your country, your state, your city, wherever you're listening from, has some resources available for you. To share your story or feedback, please reach out to us. Thank you for listening.